Graduate of the University of Alabama and the University of Tennessee School of Law. His resume is so impressive. I keep reading over and over, and I'm just honored to have him here. He has devoted his career to public service, and upon graduating from law school in 1995, he moved to Montgomery, Alabama, to work as Deputy District Attorney for the 15th Judicial Circuit. He moved to Mobile shortly thereafter, accepting a position as Assistant United States Attorney for the Southern District of Alabama, where he prosecuted drug offenses and an array of general crimes. Prior to his appointment as United States Attorney, Mr. Brown spent the previous 10-plus years working for the United States Congress. Wow. He first worked as counsel as well as Director of Education and Training for the Senate Ethics Committee. In this capacity, he investigated allegations of misconduct by Senate members and staff. After 9 years of service with the U.S. Senate, Mr. Brown accepted a position with the Ethics Committee of the U.S. House of Representatives, first as Deputy Chief Counsel, then later as Acting Chief Counsel and Staff Director. On August 6, 2009, President Barack Obama nominated Mr. Brown to serve the United States Attorney for the Southern District of Alabama. He was confirmed by the Senate in November of 2009 and began duty in December 2009. Mr. Brown happens to be the first African American to serve as a United States Attorney in the history of the state of Alabama. He is committed to making every community in the Southern District of Alabama a better place to live. And he will be speaking today on voter suppression and intimidation. We are in for a treat. May I introduce our featured speaker, Mr. Kenyen Brown. We're delighted to have you.
Thank you for that very kind and warm introduction as well as greetings. It's an honor for me to be here today. Before I get started, I want to recognize a couple of people, and that's Mr. Kennedy, who previously ran for the 1st Congressional District. Appreciate you being here. If you would stand up, I'm not sure if everybody knows you. And also a former colleague of mine that I had the pleasure of hiring on. Now, she had a distinguished career long before she met me, but I was able to hire her away from New Orleans. I see her trying to hide in the back there, and that is Holly Wiseman, Assistant U.S. Attorney. Thank you for coming, Holly. Well, I really do feel that I am once again among my people, and I don't say that in a partisan way, but I know that I'm with a group of people who advocate for the right of people to vote if they have the right to vote. So I want to thank you for that. We all should understand, regardless of our partisan affiliation, that you win some, you lose some. That's how our political system works. However, the pages of our national history are not written like that. Our history is rife with examples of excluding whole segments of our society from voting, both by broad, sweeping federal legislation to Reconstruction-era violence and intimidation performed by individuals and organizations like the KKK, and intimidation and violence like lynching, to Jim Crow-era state and municipal ordinances such as poll taxes, such as literary tests and grandfather clauses, to the more recent and insidious forms of voter suppression. Our history shows that we collectively, as a people, are willing to dilute or deny the rights of others in order to get or to hang on to political power. While there may no longer be violence or the threat of violence to suppress the vote or Jim Crow-era impediments to voting, voter suppression is alive and well in our country, particularly in swing vote states, and that's what I'm going to focus on. According to the Brennan Center for Justice, 99 bills designed to diminish access to voting were introduced in 2017 in 31 states across the country. Several states controlled by majority Republican legislatures have adopted a use it or lose it approach to citizens' right to vote. Now, I want to be clear. I'm not here to demonize one party or exalt another party. Our public rhetoric has become way too caustic and indeed has become an impediment to good governance. But on the other hand, people of good conscience have to be willing to stand up to oppression, call it what it is, and seek change. Now, we also have to demand that our government works the way it was designed to work. And in this country, we should all believe that everyone gets the right to vote and every vote should count. With that being said, in Wisconsin, a key battleground state and considered by many to be ground zero for voter suppression efforts, there's an ongoing battle to make sure that all of their citizens have the right to vote. The architect of voter suppression, the voter suppression playbook in Wisconsin, was former Republican Governor Scott Walker. Right after his election in 2010, he focused on passing legislation that would destroy free and fair elections. He implemented one of the harshest voter ID laws in the nation. He restricted early voting hours, allowed partisan election observers to go close to the polls with poll workers and voters where they were at polling places. And according to a CNN report in 2012, thanks to his system rigging efforts, Republicans won more seats than Democrats in the Wisconsin House of Representatives, despite Democrats winning a majority of the popular vote. Republicans expanded their majority in the state assembly and flipped the state senate, all while Wisconsinites in 2012 overwhelmingly supported President Barack Obama. In mid-December 2019, a state judge appointed by a Republican governor used a warped interpretation of a Wisconsin voting law to throw out roughly 234 registered voters. Now, keep in mind that Donald Trump won the state of Wisconsin in 2016 by 23,000 votes. The decision in this case, brought by the conservative Wisconsin Institute for Law and Liberty, concerned a state law that required the Wisconsin Election Commission to keep voter rolls up to date. Under the law, the commission sent letters to voters suspecting of having moved based upon quote-unquote reliable information. Those who didn't respond by affirming their address within 30 days were then purged from the voting rolls. The legal dispute also revolved around what constituted that reliable information. In this case, the data from the selected source was useful but imperfect to compare voter registrations across states. The commission planned to spend the next 12 to 24 months assessing individual cases to determine if they had reliable information before they were removed from the voting rolls. But the lawsuit, the plaintiffs demanded that not be used as a double check tool, but rather that if the system identified them as a possible double registrant in separate states, that they immediately be purged from the rolls. Well, that state court judge that I talked about agreed with them and ordered the immediate purging of 234,000 Wisconsin voters. Of course, this decision more disproportionately negatively impacted Democrats than it did Republicans. Interestingly, the League of Women Voters of Wisconsin was one of the groups that challenged the judge's ruling. They argued that the purge violated the citizens' constitutional right to be processed, since the letter sent by the Election Commission failed to first provide adequate notice about what voters must do to remain on the rolls. Second, it did not explain the consequences of not responding to the cards, that is, deregistration, and it did not inform the voters that they only had 30 days to respond. Now, I've tried to think about polite ways to say this in a nonpartisan crowd, but there's no way to get around telling the truth, and that is that our Republican brethren across the country have engaged in widespread and sustained voter suppression efforts. Now, case in point, during an appearance in Madison, Wisconsin, last month, a top Trump re-election advisor, Justin Clark, suggested a concerted, ramped-up campaign to keep voter turnout low in the state of Wisconsin and in other swing vote states. He stated, quote, "Traditionally, it's always been Republicans suppressing votes in places." Now, he said this in front of the Wisconsin chapter of Republican National Lawyers Association in December of 2019. He continued, quote, "That's what you're going to see in 2020. It's going to be a much bigger program, a much more aggressive program, a much better funded program," end quote. Now, circling back to the lawsuit that was set to purge 234,000 Wisconsin voters, thankfully, just last month, the Wisconsin Supreme Court stepped in and overturned the lower court decision, halting the purge. Now, this means that most likely the 234,000 at-risk voters should still be eligible to vote in November's presidential election. A similar voter purge took place in Ohio in 2018. Ohio uses a multi-step approach to their purging. First, it waits for someone not to vote for 2 years. Then it mails them a prepaid return card asking for them to affirm that they still live at that address. If they don't do that, they wait 4 more years, and if they don't vote, then they're purged from the rolls. The state assumes that the person has moved if there's no response, and uses the reason behind that is them moving as the reason for purging them from the rolls. Now, opponents to the system argue that it violates the National Voter Registration Act and the Help America Vote Act because these laws, these statutes restrict the state from removing someone from the rolls just because they failed to vote. Now, as an aside, U.S. Senate Majority Leader Mitch McConnell doesn't really care to protect the rights of these type of voters, these sporadic voters as he calls them, because he actually came up with a nickname for them, political couch potatoes. But think about that for a moment. Does a person lose their right to buy a gun, their Second Amendment right to buy a gun, just because they don't purchase a gun? No, of course. That's ridiculous. Now, opponents of the Ohio law also claim that the system is unreasonable in part because many people who received the return cards simply didn't know what they were for, not because they no longer live at those residences, but because they didn't know what they were for. Now, this case made it all the way up to the U.S. Supreme Court, and in 2018, in a 5-4 decision, the Supreme Court said that the voter purge system in Ohio did not violate federal laws. The court found that Ohio's system uses a lack of voting as just one piece of evidence, along with a lack of response to the prepaid return card as the trigger the person's removal from the voting rolls. In other words, since the person not voting was not the sole purpose of their removal, it was okay under federal law. This decision gave cover to 6 other states who have enacted similar laws: Pennsylvania, Georgia, Oregon, Oklahoma, West Virginia, and Montana. Now, undeterred by this ruling, Jen Miller, the director of League of Women Voters in Ohio, nonetheless reviewed the list of the 235,000 names that were set to be purged by the state of Ohio, and she found that 40,000 of those people on the list should not have been on the list because they didn't fit the criteria for purging, including herself, even though she had previously voted in the past 3 elections. Since then, she has spent her days trying to re-register people to vote in the state of Ohio. Now, generally speaking, research has shown that such purges are more likely to sweep out Democratic voters who are more likely to vote sporadically, as you've heard me mention earlier. Republican legislators typically deny that they had any partisan intention, claiming instead that the purges are a way of cleaning up the rolls and being proactive against preventing voter fraud. However, data compiled by the Brennan Center for Justice, among others, shows that instances of voter fraud are extremely rare. A comprehensive 2014 study published by the Washington Post showed that there were only 31 credible instances of impersonation fraud from 2000 to 2014 out of more than 1 billion votes cast. Out of 1 billion votes cast. Even this tiny number is likely inflated because the study's author included not just prosecutions or convictions, but any credible allegation of voter fraud. Two studies done at Arizona State University, one in 2012 and one in 2016, found similarly negligible rates of voter fraud impersonation. The project found 10 cases of voter impersonation fraud nationwide from 2000 to 2012. This follow-up study, which looked for fraud specifically in states where politicians claimed that it was such a pernicious problem, found 0 successful prosecutions for impersonation fraud in 5 states from 2012 to 2016. A study in 2011 by the Republican National Lawyers Association found that between 2000 and 2010, 21 states had 1 or 0 convictions for voter fraud or other kind of election irregularities. Okay, it's fair to say that even if there are some instances of voter fraud, given the minuscule number of cases, it's not going to tip an election. Georgia, the Intelligencer, a newspaper out of Pennsylvania, reported this past December that Brian Kemp is Georgia's governor due to one of the most controversial elections in recent memory. As Secretary of State since 2010, he had 8 years to winnow down the electorate to his liking before the campaign in 2018. And he did so by purging 1.4 million voters from the rolls, placing thousands of registrations on hold as well, and overseeing the closure and relocation of nearly half of the state's precincts and polling sites. He also invoked the so-called exact match rule. So if you show up to your polling place and your identification is a little bit different than your registration, you can't vote. The stated goal, similar to other efforts by Republican officials, across large areas of the country, was to reduce the voting power of unfavorable constituencies, black people, poor people, and students. A study from the Atlanta Journal-Constitution, published in December of last year, showed that precinct closures and polling sites relocations in the state of Georgia, in particular, prevented an estimated 54,000 to 85,000 voters from casting ballots last year, primarily by forcing them to travel much longer distances to get to their polling places. The study, undertaken by an Atlanta Journal-Constitution statistician and vetted by a team of nonpartisan experts, showed that the farther away your polling place is, the less likely a person is to actually cast a vote. The results showed that in 2018, there was a 1.2 to 1.8 drop in voter turnout. Now, Stacey Abrams, the Democratic gubernatorial candidate, lost that election by 1.4%. Hampered to begin with by higher rates of disenfranchisement due to Kemp's purges, heightened poverty rates, and varying types of involvement with the criminal justice system, closed precincts and relocated polling places made black voters 20% more likely to miss the 2018 gubernatorial election than their white counterparts. Between 2012 and 2018, the distance between the average Georgia voter's home and their polling site more than doubled, as 8% of the state's polling sites were shut down and 40% of its precincts were relocated. Roughly 30% of black voters had to cross at least half the distance of their precinct in order to cast a ballot, as did nearly 20% of white voters. Georgia has been especially aggressive in its effort to make it harder to vote ever since the Supreme Court gutted Section 5 of the Civil Rights Act of 1965, and that was done in 2013. According to American Public Media, it's one of the only states formally subjected to preclearance that has implemented all 5 of the most common voter suppression tactics: voter ID laws, proof of citizenship requirements, purges, cuts in early voting, and polling site closures. But Mr. Kemp didn't stop there, or even stop with the state of Georgia. Generally speaking, one of the requirements of the National Voters Registration Act is that, quote, all records concerning the implementation of programs and activities conducted for the purpose of ensuring accuracy and currency of official list of eligible voters be maintained and publicly disclosed. Back a few years ago, when Kemp was still the Secretary of State for Georgia, he entered into a memorandum of understanding with 19 other states, agreeing to share voter roll information in order to cross-check duplicate registrations and purge them from each state's voting rolls. This effort was also led by Chris Kobach out of Kansas, who was the Secretary of State for Kansas at the time. He would later go on to head President Trump's short-lived Committee on Election Integrity that was dedicated to stamping out voter fraud. As part of his effort, the commission wrote to the top election officials in every state and requested that they turn over their voter data. The commission disbanded in less than a year without even making a report. Now, in any event, Kemp, the Secretary of State, refused to provide the interstate cross-check purge list that he received from Secretary of State Kobach to a journalist after the journalist properly requested it. Kemp argued that he didn't use a list to purge Georgia voters anyway, despite the fact that the MOU clearly stated that that was the purpose of the exchange of information. Now, in terms of the legal posture of the case where the reporter was suing him to get that information, Mr. Kemp asked for summary judgment. That means basically, even if what the plaintiff says is true, there's no cause of action, there's no case, judge, it has to be dismissed. Well, the case was before a district court federal judge, and without the plaintiff asking for it, the reporter, the court on its own initiative issued summary judgment against Mr. Kemp and said that he had to turn over those purge lists to him and that he was in violation of the law. And this happened just 2 weeks ago. Now, the court ruled that he had to turn over the 2016 and 2017 voter purge lists that were provided as part of this interstate cross-check system. The reporter was also able to obtain by other means the cross-check list that he obtained from Kobach back in 2013. And he found as a result of that, Kemp had indeed purged 106,000 voters from the rolls on that occasion based upon that information. And the voters that were purged were overwhelmingly voters of color. Now, according to the same journalist, the interstate cross-check purge information Kemp provided to the Secretary of State of Michigan was used to remove tens of thousands of voters with names like James Brown or Muhammad, all of which had mismatched middle names. So they weren't even the same complete name, yet they were purged from the rolls in the state of Michigan. I think perhaps it's not a stretch to say that the purge in Michigan of supposed Georgia voters was the key to President Trump's official victory margin of 10,700, putting Trump over the top in the Electoral College. My point is that these actions were not done haphazardly without expected results. Now, there is some news, good news, coming out of Georgia. The overt acts of voter suppression that I've described today have energized voter registration efforts, led by former gubernatorial candidate Stacey Abrams. 322,000 voters were added to the rolls last year in Georgia ahead of a presidential election that is increasingly a competitive state. The number of new voters in Georgia has outpaced voter registration cancellations. There are now 7.2 million registered voters in the state of Georgia, a 3% increase in 1 year. About 68% of Georgia's 10.6 million residents are now registered to vote. Now, let me come back to the cross-check, interstate cross-check system. At its height, it had 29 states participating, and now it's completely defunct due to a lawsuit filed by the ACLU that relied on information that said that when they did the cross-check, based upon the fact that African Americans have more common surnames, that they had a 45% overrepresentation in the cross-check system, whereas white Americans had an 8% underrepresentation. They also had data breach problems and other problems, so that program has been completely done away with, suspended. North Carolina. In 2013, a Republican-controlled legislature made cuts to early voting, created voter ID requirements, eliminated same-day registration, eliminated out-of-precinct voting, and eliminated pre-registration of high school students. More than half of North Carolina voters use early voting, and African Americans even do so at a greater rate than that. African Americans in North Carolina also vote overwhelmingly on the Democratic ticket. Those provisions of the law that I just mentioned were struck down in July of 2016 by the Fourth Circuit U.S. Court of Appeals. In its ruling, the appeals court said that it was intentionally designed to discriminate against black people. The court found that North Carolina legislators, you have to get this, had requested data on voting patterns by race and then used that data in hand to draft what the court called to target, quote, target African Americans with almost surgical precision, end quote. The case was appealed to the U.S. Supreme Court, and in 2017, the Supreme Court refused to hear the matter or overturn the appellate decision. But it didn't stop there. The same Republican-controlled legislature then passed a new voter ID law over the veto of the Democratic Governor Roy Cooper that required specific forms of identification at the polls. The new law would have allowed voters to present a driver's license, a passport, or a military ID in order to vote, but not a public assistance ID card, also issued by the state. The federal district court judge that heard the legal challenge to the law ruled that it was, quote, particularly suspect, end quote, as nearly 29% of North Carolinians who use SNAP benefits were black. The judge further stated that, quote, the evidence suggests that minority voters are not just less likely to have an acceptable form of ID, but that the legislature excluded photographic ID that could have greatly reduced the disparity. In striking down the law in late December 2019, like a couple months ago, the judge ruled that the law was the latest example of North Carolina's, quote, sordid history of racial discrimination and voter suppression, stretching back to the time of slavery through the era of Jim Crow and crucially continuing up to the present day, end quote. In addition to blocking the voter ID portion of this new law, the judge also blocked a portion of the law that allowed poll watchers to challenge someone's ballot if they didn't have the proper ID. So in other words, you go up to your polling place, you might have forgotten your ID and you're trying to present some other form, and some posse of poll watchers, they're not authorized by the state, they're not poll workers, had the legal authority to come up to you and challenge your vote, challenge your ability to vote. Now imagine the intimidation and the chaos that would have ensued from that. A state legislature in our day and age, in our generation, in our time, passed this law. Well, this would have been every bit as bad as Jim Crow era or Reconstruction era voter suppression. Can't make this up. The Republican Attorney General for North Carolina has indicated that he plans to appeal that decision. Michigan. As you heard me allude to earlier, Michigan participated in the controversial interstate cross-check system. However, instead of using the system for an immediate basis for taking a person off the voter rolls, Michigan used it to jumpstart an investigation about whether or not there was a double registration. Also, a lawsuit filed just this past November challenged a Michigan law that prohibited people from hiring vehicles to transport groups of people to go to the polls if those people could otherwise walk to the polls. The argument is that the law has a disparate impact on the poor, many of whom don't own a car. This law would theoretically prohibit a church or a civic organization or a group of neighbors from hiring a van driver to take people to the polls. Really? Really? Yep. What does it matter how you get there if you have the legal right to vote? It's just another small way of making voting more difficult for certain populations. Another Michigan law bars people from handling other people's absentee ballots. So for example, no one can gather absentee ballots from a nursing home facility. So this law presumes voter fraud and is proactively restricting people's choice to vote by absentee ballot. The fight continues. Pennsylvania. Republicans in Pennsylvania passed a voter ID law in 2012, but state judges blocked its implementation for 2 years. The state Supreme Court also struck down a heavily gerrymandered redistricting map drawn up by a Republican-controlled legislature in favor of a more balanced map. Pennsylvania has no early voting. Early voting, particularly on Sunday, would make it easier for low-income workers to go to the polls without risking losing their jobs. So this law is disproportionately impactful in a negative way against minority voters, poor voters, and students. Pennsylvania also participated in the interstate cross-check program run by the former Secretary of State of Kansas. Under Pennsylvania law, voters who have not voted for 5 years and who fail to vote in the next federal election are also removed from the rolls. New Hampshire. New Hampshire is a small swing state where both state and local elections, as well as federal elections, are decided by a razor-thin margin. Donald Trump lost the state to Hillary Clinton by just 2,736 votes in 2016. Republicans in the state have long complained about college students voting in New Hampshire. William O'Brien, a Republican, and then the New Hampshire House Speaker said in 2011, quote, "They are kids voting liberal, voting their feelings with no life experience," end quote. Well, the Republican-controlled legislature eventually passed a law to address that issue. They passed a law challenging the legal definition of what it meant to be a resident of the state of New Hampshire, adding a new requirement to vote. Under this new law, if a student drives, they need to get a New Hampshire driver's license and register their car there before they can vote. It used to be that students or other part-time residents could vote in New Hampshire if they were domiciled in the state, which basically means they spend more time in that state than they do any other. Critics of the law say that it's the equivalent of a new poll tax for college students that they can ill afford to pay. Supporters of the new law argued that the law was intended to make sure that only New Hampshire citizens voted in and influenced their elections. In late November of last year, a federal district court judge denied the request to block the implementation of the new law. Missouri. Early last month, the Missouri Supreme Court invalidated part of that state's voter ID law. The new law directed citizens to present a government ID photo in order to vote, but it also allowed them to cast a ballot presenting some other identification as long as they signed an affidavit as well, an exception known as Option 2. That provision formed the basis for the court battle. Again, under Option 2, a voter could present some other form of non-photo ID, such as a utility bill, a bank statement, or a school ID. But if you presented the lesser form of ID, you had to sign a sworn affidavit. And this is the sworn affidavit. Quote, "I do not possess a form of personal identification approved for voting. I acknowledge that I am required to present a form of personal identification as prescribed by law in order to vote." Let me read that again, a little bit slow, okay? "I do not possess a form of personal identification approved for voting. I acknowledge that I am required to present a form of personal identification as prescribed by law in order to vote." So essentially, this affidavit forces people to swear that they did not have the right to vote, even though they're there under the law and they can vote legally. So what did that do? That made people afraid to sign the affidavit. They didn't know if they would be prosecuted for perjury. It was completely confusing. And the court ruled that this was unnecessary and confusing and could lead to voter intimidation and suppression, and threw it out. Now, state of Florida, there are many things that I could talk about there, but I'll focus on the one closest to my heart. In 2018, an extraordinary coalition of groups from across the political spectrum helped to push what's known as Amendment 4. which restored the voting rights of nearly 1.4 million Floridians with felony convictions in their past. In Florida, a constitutional amendment needs at least 60% to become an effective constitutional amendment. In the final tally, Amendment 4, which allows all felons except those convicted of murder or sex offenses to apply for restoration of their voting rights. They got nearly 65% of the vote in Florida. So, Florida voters across racial, economic, and party lines came out in favor of re-enfranchisement. Now, keep in mind, in Florida in 2016, Trump beat Hillary Clinton by a total of 113,000 votes. A Tampa Bay Times Miami Herald analysis found that 52% of the Floridians who lost their right to vote due to a criminal conviction were Democrats, a third were independents, and 14% were Republican. In recent years, black voters were 5 times more likely to lose their voting rights than whites in the state of Florida. Democrats were 3 times more likely to lose their voting rights than Republicans in the state of Florida. But overall, the majority of formerly incarcerated persons were white Americans. The Florida GOP-controlled legislature quickly passed a law stating that voting rights could only be restored if their fines and fees were also paid off as well. This is near impossible, and I've worked a lot with formerly incarcerated. They come out many times with nothing. So paying all the court fines and fees is basically telling a whole bunch of people, yeah, the state voted for your right to vote, but you can't vote. Now, news report, but there was a provision in the law that allowed the sentencing judge to go back and amend their sentence and waive court fines and fees. News reports indicate that many democratically controlled counties have instituted initiatives to try to get the judges to waive the fines and fees of the formerly incarcerated. However, no GOP-held county has yet initiated any similar program. This could have the unintended consequence that more Democrats have a chance to get their voting rights restored than Republicans. But this story is yet to be told. Now, I would be remiss, even though it's not a swing state, if I didn't talk about Alabama. For context, we have to remember that Alabama was one of the states with a history of discriminatory election practices that required DOJ pre-clearance prior to making any election law changes. Prior to Section 5 of the Civil Rights Act being gutted in 2013, DOJ blocked more than 80 proposed voting changes in the state of Alabama. Since then, Alabama has enacted a strict voter ID law. Under this law, voters have to show one of a limited number of state-issue IDs. It's estimated that more than 100,000 Alabamians do not have acceptable IDs under the law, according to a unsuccessful lawsuit filed by the NAACP. Alabama is also one of only 4 states that passed a law that required individuals to provide documentary proof of citizenship prior to them being able to actually register to vote. There have been polling place closures that have predominantly impacted African Americans, specifically in 2015. ID issuing offices were closed in 6 counties that were majority black by 70%, although voter registration stations did remain open in those counties, and that's compared to 40 stations remaining white and remaining open in 55 counties that were majority white. Now, in terms of the Secretary of State in Alabama, he did not come out and popularize or spend much time on publicizing the fact that formerly incarcerated persons could actually register to vote. And when he actually did come out and say something, he incorrectly stated that the formerly incarcerated person had to pay fines and fees before getting their rights restored, creating confusion, and possibly many people seeking it might not have done it, thinking that they couldn't because they had outstanding court fines and fees. Now, our Secretary of State denied any impropriety there. He points to the fact that since January of 2015, the state has registered 1.2 million new voters. He also pointed to the fact that black voters' participation was almost equal to that of whites in the 2018 midterm election. Now, was this voter registration surge due to get out the vote activities in response to suppressive activities, or were these just natural occurrences? We may not know for some time. Lastly, partisan gerrymandering has been viewed by some as a guise for voter suppression. Every 10 years following a census, states have to redraw their districts and state houses as well. Partisan gerrymandering is a tool for politicians to manipulate the lines of the district in the way that benefits them. They create a system whereby the politicians pick their electorate rather than the electorate picking their representatives. While it's true that gerrymandering has been used by both parties for over 200 years, it's worse than it's ever been today. As an opinion published in the Concord Monitor aptly stated, quote, when politicians represent a gerrymandered district, they are more concerned with special interests and the extremes of their party than finding compromises that further the interests of the people. Gerrymandering is part of the reason why our politics are so polarized and our political leaders keep debating critical issues like rebuilding our infrastructure or reforming our immigration system, but nothing gets done, end quote. Gerrymandered districts dilute the vote of some communities and improperly augment the views of other communities. That's why a number of states have implemented independent, nonpartisan redistricting commissions to help make politicians of all stripes responsive to their constituents and more likely to seek common sense solutions that a majority of Americans support. Well, my time's almost up, but I hope that you've been informed and enjoyed my survey of voter suppression efforts taking place across America. And while we might be of different political affiliations, I hope as Americans we can all fundamentally agree that we should all be able to exercise our right to vote. Political speech is a protected First Amendment speech, and so drawing from that context, I hope that we can all agree that while I might not agree with what you have to say, I agree with you for your right to say it. Lastly, I hope that everyone in this room feels the outrage that I felt when I was doing this research and learned of so many schemes and efforts to limit or take away the voting rights of our neighbors and sometimes even ourselves. Thank you. Okay, I almost walked away. I forgot. Questions? Any questions? Yes, ma'am.
I gather from what you said that the Greater Birmingham Ministries lawsuit against the state on the issue of voter ID, is that dead in the water?
I think that is dead in the water.
Because it was my understanding that it was up on appeal to the circuit court.
That's
and
correct.
that it's still sort of lingering.
No, it has been decided now.
Okay.
Yeah, it has been decided. Adversely against the action that was brought by the plaintiff.
Well, the candidate applied.
Yeah.
The League of Women Voters about signed on as a friend of the court in that lawsuit.
Yes.
And I just haven't gotten the message.
Mm-hmm. Great question. Yes, ma'am.
Could you please explain exactly how the Voting Rights Act got gutted?
Right. Basically, the Supreme Court in 2013, in this case originated in Alabama, Section 5 required pre-clearance before districts or states with a history of racial discrimination could change any voting laws, do closures and things like that. The Chief Justice of the Supreme Court said that while this may have served and I'm paraphrasing broadly, may have served a purpose in the past, there's no evidence now why certain states should be subject to this while others have not, and there's been an evening of racial attitudes nationwide, and so since it's applied disproportionately and there's really no reason for it anymore, we're going to discard it. And I'm saying that very broadly. So the court basically found that there was not a basis formed in racial discrimination anymore where it was needed. Yeah, as we see, it's still needed. Yes, ma'am.
I noticed that a number of the things that have taken place, like no rentals, basically, so we can have the vans picking up people at church and all that. A lot of these are discriminating against the elderly. And also, getting the voter ID is very discriminating against the elderly. And when John Merrill was down here speaking to the League of Women Voters in Baldwin County, many of us from here went over with them, and he thought he had a friendly audience in Baldwin County, and he found out very quickly he did not. And we were kind of staying back and being quiet, and they hit him, and so did we, about the fact that the elderly were having so much trouble getting documents to get voter ID. Many had given up their driver's licenses because they were no longer driving, and then were trying to scurry around to get birth certificates, and some had been home births and didn't have birth certificates, and scurrying, get all this stuff together because you have to have your marriage certificate because your name is different and all the rest. And he was just like, what are you talking about? Like he had no clue of what was going on. And I think he still was in that la-la land. Nobody has a problem getting an ID card because I'm running around on my bus helping people.
Yeah, he has said that those type of claims are not proper because he has issued 11,000 IDs. But the fact is, you still have to get out to get it. And if you are elderly and not physically able to get out to do that, or it's not easy to do that, you might not vote. If you are poor and you don't have a means to get to a voter ID office, during regular working hours, then you are at a lesser advantage to be able to vote. I think the broader point is we should be making it easier for citizens to vote and do their civic activities than trying to stop people by creating unnecessary impediments. Yes, ma'am.
This is kind of in line with what she was talking about. For years, I voted absentee because I was out of town. And I would call down to the probate judge's office, and they would send me the application and so forth and so on. In 2018, I was going to be out of the country. So I called. They were very rude, told me I had to call the Secretary of State. I'm computer literate. I can find it on the Secretary of State's website. But if you're elderly, just trying to get into the system to find an absentee ballot, if you don't know that it's an election, then you can't find it. Plus, who's most likely to apply for an absentee ballot? The elderly. My husband can't go to the poll in the primary. So this morning, I went online, and it took me a while to get go through all of the different pages or whatever to find it. I think something needs to be done about that. Plus the fact, a lot of your elderly don't have computers, number one. Secondly, if they have them, they don't know how to go through all of this. And then, when you file for an absentee, like I was telling my husband, how many elderly even have a printer at home to send a copy of your photo ID? It's ridiculous. And then when I went to the poll workers training, they're saying that you have to go, if you want to go downtown, you have to physically go. If you handicapped or you elderly, how can you go to Government Street and get up to wherever you have to go?
So I think that's not a question. I'm just going to say amen and preach. And also that we have to hold our elected officials accountable. I love that the League of Women Voter members in Baldwin County held them to task. These are sometimes difficult questions to answer, sometimes not. But again, I think the overall spirit of our election system is that people should have access to vote, and we should be creating different avenues for people to vote. Yes, ma'am.
besides the phenomenal work that Stacey Abrams has been doing in Georgia, do you know of other specific cases where that type of thing has been done to get people registered or re-registered? And do you know specifically anything about the way Alabama's doing it?
Unfortunately, I don't know what Alabama's doing besides this organization.
Yeah.
Trying to do that. But from the research that I was able to do leading up to this, is that the League of Women Voters is kind of the tip of the spear nationwide in challenging some of these modifications and rules that hamper voters. So I mentioned two, one in Ohio, and I think the other was Wisconsin, where they challenged it. But it's civic organizations, good citizenship organizations. Yes.
Well, sort of a comment on that. With respect to the Shelby decision that got the Voting Rights Act, a few months ago, Representative Terry Sewell passed the Voting Rights Restoration Act, and it sits among the 400 plus bills that have passed. So there's work with the For the People Act, the Voters' Rights Restoration Act, to make that more equitable nationwide. As far as in Alabama, there are a number of organizations that are working on the various ways that voters are disenfranchised. The NAACP is doing a lot of work very specifically with rights restorations for the formerly incarcerated. That's a lengthy process. It can take up to 2 months just with the paperwork being filed. So if you're interested in that, the NAACPs in the different counties are holding workshops and organization. And honestly, a lot of it is coming with political candidates. You know, as we're out canvassing, we're knocking doors, we're talking to people. We've got our phones with us. I register people every day. We check registrations every day. So Organize Alabama is working really hard statewide to kind of get things out. But it's a lot of small groups. There is a larger group called our Project 2020 based out of Mobile that's trying to bring these small groups together to have everyone coordinate a little better. And if you're interested in sort of being a little bit more boots on the ground after this, I can sort of connect you to those people. But right now, it's a lot of small groups like this see the problem and are like, we need to do something about it. So it's kind of about building a coalition and getting that forward momentum. But NAACP is really doing a lot of it in Alabama.
Great, thank you. Yes, ma'am.
You know, I want to appreciate the fact you came and gave us this information, because a lot of us do a lot of work to get people to register and get them out to vote, and we run into a lot of issues with this. The information you gave me today, I can use to get people to register. We need to know that kind of stuff.
Is it
So I thank you so much.
Is it online or somewhere we could access?
It's
Wonderful research?
It's not. I'll be glad to put it in a format that you could use it. This is kind of ready for my speech, but give me a week or so and I can put it in a form that you can use as a resource.
Could you give that to Myra, because she informed
Yes,
us.
I know Myra very well.
Betty.
Yes, sir, Mr. Battles.
Mr. Brown, 2 weeks ago, I convened a meeting at Henry Roberts Church with the NAACP Legal Defense Fund from New York and from Washington, D.C. Their interest was to, in conjunction with the violation of Section 5 in the Voting Rights Act, their interest was to sue a local community in our town, I'm not going to call, that still has an at-large form of government, and to look at the 13th Judiciary too, for the lack of African Americans' opportunity to win on a county-wide basis. And so what the premise was, they wanted to get 3 cases in Alabama. They contend that if they could sue and successfully litigate 3 cases in Alabama, then that would be a precursor to going back to the legislature to try to get Section 5 reinstated as far as the pre-clearance for Alabama, which has a history of discriminatory practice.
It's fascinating. Thank you for that information. Okay. Yes, ma'am.
This would be my first year to work as a poll worker. And so I know one thing, that if we're doing the check-in and everything, if you come in with a picture ID and your address doesn't match what's on the record, deny you, but you can always file a provisional vote. Then they will allow you to do that.
Not supposed to check your address.
They do.
Yes,
I
they are
was-
this
I
time.
was
Check your address
voted
and
last
some
time, and
card.
somebody right in front of me got sent
Yeah.
from doing provision.
I got done that way.
I have stopped using my driver's license for that reason.
But I'm just saying that there's no reason for people not to be able to vote. And the other thing was about the picture ID was that, you know, getting an official one, driver's license bureau or something, might be cost prohibitive for some people, but at the probate court, they would give you one for free.
Mhm. Also, as a poll worker, you can, if they don't have an ID in Alabama, if you recognize a person,
Yeah, two people have to recognize
Yeah.
you.
And one other thing is the poll workers are all volunteers. So depending on the knowledge of that poll worker and that person in charge of the poll, people may or may not get to vote because the information is just not balanced, and it's a horrible system. We've got to do something to improve it.
time's up.